Welcome to the AWA Market Minute, breaking down current economic, financial, and political events that impact today's retirees. Our investment committee performs hours of research and analysis every month so that we can share simple summaries with our clients in 30 minutes or less. Featuring investment advisors Jaron Monk, Mason Page, Chief Investment Officer Scott Hoxer, and your host, founder and CEO Paul Coles.
Well, welcome everyone to this month's edition of our AWA Market Minute. We're really excited to have everyone join us today for a call on estate planning. A couple of quick housekeeping items. As always, the information that we cover in these market minutes is designed to be educational in nature and for a general and broad audience. It's not designed to be specific advice. So please, if there's anything that you guys want to talk through after this call, reach out to your team here at Alliance Wealth Advisors. We'll introduce you to the attorneys necessary to kind of help you through the planning components. But please don't act on any advice that we talked through today. Maybe one other quick housekeeping item. Scott, we've got a party coming up.
Yeah, I can't wait.
Yeah,
it's that time of year, right?
That time of year. So summer's in full bloom, and we're well, at least we think it is. We can't decide if it's still going to rain or not. But we have a party coming up on June 20th. And so if you're hearing my voice, you're invited. We'd love to have you join us. June 20th at Eaglewood Golf Course Clubhouse. We've got 2 different sessions because we have too many people to host. So it's kind of an open house feel that we're doing dinner and some raffle and there's a band there. It's going to be a lot of fun. So there's a 5 o'clock to 6:30 and then a 7 to 8:30. And if you want to join us for that, you just need to RSVP, reach out to Elisa, check your email inbox. We'd love to have everyone come and say hi. And it's just an opportunity for us to visit with our clients in a social setting. And we love what we do. It's a lot of fun. The elements of planning and the investing and the numbers, we geek out on that stuff. But I think more importantly, we love who we get to do it for. And so these are one of those, opportunities where we get to sit and visit in a social way. And that's a lot of fun for us to deepen those relationships. So before we introduce our guest host today, I wanted to just kind of set up the conversation with a story from back when I was in college. It was just as I was finishing up my degrees at the U, and I was just been married, and at that time it was about 2004, and there was a news cycle, a story that had made the news, and it was one of these like 24-hour news cycles that it was just every time you turn on the TV, it was this story. It was the story of Terri Schiavo. Do you recall that story?
I do. I can't believe it's been that long ago.
It has. Yeah, it's been almost 20 years now since this was going on. And the backstory to the Terri Schiavo story was that almost 10, 15 years earlier, prior to the big news cycle, Terri was married and she suffered a major cardiac arrest, which put her into a persistent vegetative state. She lost all of her cognitive abilities and in all regards became a vegetable. Her husband at the time moved on with his life because her mother stepped in and became her full-time caregiver. And her mother, would visit with her and she'd walk in the room and she would believe, she would smile and her eyes would light up and she would grunt and her mom would feed her and they would visit. And her mom did this for better than a decade, taking care of Terri while the husband was estranged and not part of the family's picture. Flash forward to this event back in circa 2004. The estranged husband came back into the picture and said, "This is not right. It's not humane. In honoring the memory of my wife, we need to let her die." And the mom said, "Over my dead body. You're not taking my Terri from me. She's in there. She lights up and grunts and she communicates with me in that way and you can't take her from me." And it turned into this, big drawn out legal battle. And the battle was over whose right should it have been to make the decision to allow Terri to live or to allow Terri to die. I mean, they say if anybody in this world loves you, it's your mom. And the mom said, it's my decision because she's my daughter and I love her and I've cared for her. However, legally, they enter into a marital contract. The husband has rights as well to be able to step in and help make decisions. And so this went before a judge, and the judge had to rule on whose decision it was. Was it the mom's or was it the estranged husband's? Ultimately, the judge ruled in favor of the estranged husband, and the estranged husband allowed Terry to die. The point of my story was this. At the time that this happened, it really didn't sit well with me, because what I kept thinking was this should have been Terry's decision. Not the mom's, not the estranged husband's, but Terry should have been the one who was to make that decision. And I was just finishing up my degree in finance and got ready to start my career in kind of the world of financial planning. And it occurred to me then and there the necessity for estate planning as an integral component of financial and retirement planning. You can work really hard to save and invest your money and lose a lot of that, if not all of that, by not protecting that money through the appropriate elements of planning in other regards. In this case, estate planning, virtually would have wiped out this family because of all the legal battles that ensued. So in that vein, I want to talk today about estate planning. And Scott, why don't you go ahead and take over and introduce our guest?
Yeah, and I like that introduction, Paul. And this is very much a space where it's, an ounce of prevention is, a pound of cure, and a little bit of work on the front end can make life, so much better for your heirs and for your estate. So we're super privileged today to have Scott Dopp join us. And Scott's a longtime friend and an attorney who we work with on a regular basis, and very credentialed and experienced in the estate planning realm. He worked for years as a prosecutor and has kind of that background, and then has also worked in the estate planning realm, and that's kind of where he's currently at. So, with that, Scott, thanks so much for joining us. Pleasure to have you with us.
Thanks for asking me to come. I'm excited to be here today.
Great. So what I think we'll do today, Scott, is kind of kick things off with just some of the basics of estate planning. They're basic concepts, but super important and often misunderstood. So tell us, Scott, what a will is, a term that's thrown around. What's the kind of legal definition of a will?
Well, basically, a will is a legal document that allows you to decide who you want your personal representative to be, and who you want the beneficiaries to be, how much you want to go to them. There is a problem with a will, though. The problem with doing nothing or having a simple will is before assets, especially if you own real property, can transfer to the beneficiaries, it would first have to go through the probate process.
Yeah, so maybe a way to think about a will is something that kind of communicates your desires, but is kind of, only halfway in terms of probate avoidance and other stuff. We'll talk about probate here in a second, but a corollary to that, what is a trust?
So a trust would be a document that goes a little further than a will does, and if it's done correctly and if the trust is funded correctly, you're going to avoid, number one, the probate process. But number two, it's going to give you the ability to make a lot more decisions in terms of when the beneficiaries receive the assets, in the event you have minor children, or we're going to maybe talk about this a little further if you have a child with special needs, a child that has issues with creditors, different things like that. So a trust allows you to name a trustee, and then what you do is you fund the trust so that when the trustor, the person who creates the trust, passes away, there's no need for probate. You've named the person that you want to be responsible, which is the trustee, and you've put in that additional information about how and when you would want those beneficiaries to receive their assets.
Okay, so maybe just a follow-up. I want to go even one level more basic. We talked about a will and a trust, and you mentioned this word probate. Tell us what is probate, and why do we potentially want to avoid probate?
Okay. First of all, I think the reason you want to avoid probate is it costs money, and it also takes some additional time for the beneficiaries. So you think about a situation where children are going through an emotional bereavement process of losing a loved one, then you throw in the added cost and the time that it would take for things to go through probate. So let me give you an example. If mom and dad own a home and it's in their name and they pass away, the only way to legally transfer that to the new buyer would be for the probate court to name a personal representative. The judge signs off on that document, and then that person has legal authority to then transfer that asset. So
one way I like to think about this, Scott, because a lot of people get confused on this. I mean, if you think about it just logically, if mom and dad have a title to their name, it's recorded at the county, it's got mom and dad's name on it, on the title. If they die, a well-meaning child goes down to the county and says, hey, we want to get mom and dad's title. The county doesn't have any authority to just hand over a deed. The county can't just say, hey, here's your deed. And how does the county know who that deed belongs to? There could be creditors involved. And so that's how I often will help people say, probate says somebody is deciding who gets the stuff if the stuff is basically unclaimed. If there's not clear direction on who gets it, probate decides how it gets distributed.
That's exactly right. So if mom and dad were alive, they could do whatever they wanted. Even if the house was in the trust, they still have full control to sell it. If they want to purchase a new property, because they're alive and they can sign a deed. And just like you said, if their name is on that, the probate court has to name a personal representative, and then legally that person has the right to sell it. But again, with the trust, you can avoid that whole process.
Right. So a will, and this is often comes up a lot. So maybe just, does a will avoid probate?
No, it ensures probate. Doing nothing and having a will ensures probate.
Right. And so a will does not avoid probate. And then a trust basically says this other entity owns the asset, right?
Correct.
And so if mom and dad die, the other entity has not died, and it can still maintain and control and manage the asset and ultimately distribute the asset. And that's how it avoids probate.
That's correct. And in your trust, you've named a successor trustee that you've analyzed carefully with me, with your financial advisors, on who that person is, who the most responsible person is to be able to have legal authority to sign that document if they're selling it to a neutral third party. Or if one of the children wants to buy the home, they can do that. Usually they'd have to do that at fair market value, unless the trust document indicated that it would be sold to one of the children for less than fair market value.
So which one do you typically need? If you're an average retiree, do you need a will? Do you need a trust? What do you need?
That's a great question. And when you're creating a trust, you need actually a trust, and then we always create what we call a pour-over will. The reason we have a pour-over will is every once in a while, a person will fail to properly fund the trust. So let's say they have a bank account in their name. They don't have a payable on death on that account. They pass away. What the pour-over will is going to do is say that it was their intent to transfer all of their assets into their trust. And if they inadvertently left it out, the pour-over will pours it over into the trust. Then it would be treated as if it was in the trust for distribution purposes. So we always have a trust and a pour-over will as an important element of their entire estate plan.
That's perfect. So in essence, the answer is both.
Correct.
Love it. Are there any other documents that we need?
Yeah, in fact, I loved your introduction because you led into the fact that a lot of people think that an estate plan is only planning for death. And it is that, but there's an important element of an estate plan, which when we create an estate plan, we have what we call lifetime documents. So like you described in the Shivo case, we would create, when we create the trust, a power of attorney for healthcare, which is called an advanced healthcare directive, where you get to name the person that you trust to be able to make that decision about your end of life, and also to give a doctor permission to perform a procedure. In addition, we would create financial power of attorney documents, which I think we might get into. I have a lot of people come in and say, oh, I don't need a financial power of attorney because I have one of my kids on my bank account.
Yeah.
We can get into why that's not a great idea. But the trust, whenever I refer to a trust, really I'm referring to a whole package of documents that includes lifetime planning as well.
All right. So we've got these ideas of a power of attorney, and so Scott, correct me, if I'm wrong, but basically that's saying while I'm alive, given certain triggering events, I'm going to give permission to somebody to make decisions on my behalf. But again, it's the caveat being while I'm alive, and certain triggering events which then grant this authority, and that could be to act on my behalf from a financial perspective or from a medical perspective, correct?
That is correct. And what you call that person is your agent. And you could have the same people. You could have a different individual who's in charge of finances. You could have a different person who's in charge of healthcare. And one of the things I think is really important, and one of the things I love about estate planning, is I get to meet with people. I get to talk to them. I get to ask them about their children. And oftentimes a client will say, well, I want to name this person as my healthcare agent. And I will say, well, this person lives in New York. Would that be the best person to name, because they're not going to know all the ins and outs about your healthcare? Is there one child who lives closer who is driving you to the doctor appointments, different things like that? So it's really important to sit down and analyze who you want to name in those capacities as the agent.
And I think the other thing that we'll see a lot is we'll see people, they feel like almost like a sense of honor to bestow upon a child this right of like, they're going to be my trustee, or they're going to be my personal representative, or they're going to be my healthcare agent. And what we have to explain is, one, being a trustee is it's not like it's some kind of fantastic honor. First off, it's the equivalent that I teach people is, if the kids are all sitting around Thanksgiving dinner and they're all watching the football game, and mom and dad come in and tap you on the shoulder and they say, will you come do the dishes while everybody else gets to watch the football game? That's the honor bestowed upon you for being the trustee. You get to do all the work while everyone else gets to reap the same beneficiary benefit. I mean, it's a little bit maybe overstated, but you get the idea. So when it comes to the different roles, you can really be specific, right, and intentional, and say, hey, maybe this one daughter is emotionally in tune with my emotional and physical needs. Maybe I'll name that person as my power of attorney for healthcare, but maybe a different son maybe lives close by, and I can name him as an agent for my power of attorney for finance. And then maybe a different group could even be my trustee. They don't all have to be the same person, right?
Absolutely. And I think that's a really important distinction that you made. And when I meet with people, I spend a lot of time getting to know them, having them tell me a little bit about the family. And honestly, I can't tell you how many people I've met who've acted as a trustee for a family trust, and they've told me that they don't even talk to their siblings anymore because during that process, something went awry, someone said something. And so what I like to do is educate my clients and let them know that, hey, there's also opportunities to name corporate trustees. I actually have a corporate trustee on my trust because if my wife and I died tomorrow, my youngest daughter is only 11, and my trustee would be acting for a period of 14 years. And what that trustee's role would be at that point would be to be an investor, to take my life insurance proceeds, equity in my home, and they're going to be investing that money so it's growing. And it's important to have a direct link with a financial planner or someone that you've named who's going to invest that money. So it's something that I sit down and go over in detail. A lot of times a family may say, in order to avoid fighting, I'm going to name all of them as a co-trustee. And then I talk to them about the issues, the pros and cons of that. And in my opinion, that leads to more issues than not. So it's a really important distinction to make, that we're going to sit down and analyze who the best person would be to be the healthcare agent, who would be the best person to name as the financial agent, and who would be the best person or entity to name as the trustee.
Yeah, and on the topic of trustees, Scott, our understanding of serving as a trustee, you act in a fiduciary capacity, correct?
That's exactly right. They have a fiduciary duty to carry out whatever the language in the trust said. And so I often, people find it funny, but I often tell them, like Paul was saying, the dishwasher is the one that's doing all the dirty work. It's nice to have all the beneficiaries sometimes on the same side of the table. And if the beneficiaries don't like what mom and dad put into the trust, if you have a corporate trustee or whoever the trustee is, they're saying, I'm just carrying out my role. I have a fiduciary duty to follow what the trust language says.
Yeah, and I think the distinction for people, and I think this is super important, is that when you act as a fiduciary, you have legal liability to act in good faith and in best interest. And so that precludes you as a trustee from being able to act in an arbitrary manner or, not execute the exact letter of what the legal document, spells out. So, unless you're willing to, hold to, kind of that high standard, there are instances where I think a corporate trustee does make a fair amount of sense.
So Scott, about this point, as we've gone through, we talk through, with a client and we say it's time to go talk to an attorney. Oftentimes it's starting to get a little bit overwhelming right about this point in the conversation where a lot of people are like, hey, that seems like a lot of work, and they get overwhelmed and they feel like maybe there's a shortcut. And we see this a lot where people will say, maybe there's a shortcut. Maybe I can DIY this. Maybe I can, because the people often want to only use the methods that they're familiar with. And so one common thing that we'll see is people will say, I'm going to just go ahead and put my kid's name on my house as a title to my house, and I'll do the same maybe with my bank accounts. So two questions here. One, does that actually avoid probate? Is that
Yes?
Yes, it does, right? It does. And then two, is it a good idea?
Absolutely not. And I see it a lot too, where people come in and say, again, I don't need a financial power of attorney because one of my kids is on my bank account, or I've already transferred my home to one of my children. And that makes me cringe, because let's say a client has put their home in the name of one of their kids. First of all, that client of mine, the person who's creating the trust, has lost control of an asset that they may need. They may need to sell that. They may want to move. May want to do many things with that. But if it's not in their name anymore, they've lost control of that asset. The second thing is there's, and you can follow up on this, there's some tax issues. When you transfer real property at death, the property gets what we call a stepped up basis in the tax value. So if mom and dad bought a home for $200,000 and it's worth $900,000 when the second of them passes away, if the kids decide no one wants to buy it and they're going to sell it, if they sell it, there's absolutely zero capital gains tax. But if you transferred it to one of the children during lifetime, there's almost guaranteed to be a capital gains tax. The other issue with putting a child on a bank account is that child has equal access to the funds. Or if they're named as a POD, it goes to them, not to any of the other children. And I've run into a lot of issues with those things. We have a power of attorney in place for a reason. We don't need to have a child listed on a bank account or to put that on a piece of property.
I mean, it ultimately, the power of attorney does the same thing for life while they're alive, but it mitigates
the liability.
So we've had experiences where we knew an individual who their son was a police officer, and she said, I don't worry about my son, being on my property title or my bank account because he's a good man. And for the record, everybody's kids are good kids. It's the other people's kids that are bad kids, right? It's not my kids that are the bad kids. No, I'm just kidding. But
right.
but that was this client's feeling, was because he's a police officer, he's not going to ever take advantage of me. He's never going to come in and take money out of my bank or do anything with the title of my home, kick me out without control. And that's true. He didn't, but he did get involved in a liability, a civil liability got brought before him because of his role as a police officer. He was involved in a wrongful death shooting, and that liability transcended any of his insurance policies, and they ended up going into his personal assets, which included his mom's bank account and the deed to the home. And the mom, sat there, and the son sat there and said, hey, this is not really my stuff. It's my mom's stuff. But legally, it was his stuff once his name was on the titles.
That's exactly right.
Yeah. So there's a lot of reasons why that's a critical element. I think one other thing, just to make sure that we're super clear on, is that powers of attorney only work while you're alive. After you've passed, those documents are my understanding is they're null and void, and at that point, what governs becomes the will or trust.
That's right. That's why I like to call them lifetime documents. While you're alive, you're naming an agent, saying if I'm unable to do this, I'm giving authority to my agent. The second you pass away, the agent's authority stops, and that's when a trustee provision would then come into play.
And not everybody understands this, right? I mean, even like financial institutions that should understand it sometimes don't. I was in line once at a bank, and the individual in front of me in the line, I just happened to be close enough that I could overhear the conversation, stepped up to the teller, the counter, and talked to the teller there and said, hey, my mom's passed away, but I'm her power of attorney and I need to withdraw some funds from her account. And he produced the power of attorney document, at which point the teller began to help him withdraw funds from the account. And I sat there and thought, yeah, that's not how that's supposed to work.
That's exactly right. It ends, that agent's authority ends at death.
Yeah. We have just a couple quick minutes left. Let's go a different direction and talk. A lot of people want to ask about like long-term care and trust planning. What advice can you give people in that space?
Well, it's a difficult question to ask quickly, but basically the type of trust I'm usually setting up are revocable trusts. And so there are different types of trusts called irrevocable trusts. There are some types of trust you could set up for Medicaid type planning. So I would sit down with the client and analyze where they're at, what type of medical insurance they have that they currently have. And I like to really get into the specifics with a client before I would ever get into recommending an irrevocable trust. You want me to go into the different types of irrevocable trusts?
Well, I think maybe, just a scenario and instances where like that Medicaid kind of planning makes sense. I mean, the way I've always thought about it, Scott, and feel free to, kind of correct me here, but if one is in a situation where you have two spouses, one spouse is facing a prolonged illness that requires a lot of care. So early onset dementia, you're looking at like a 15-year runway where that person could be otherwise healthy, but the cost of care is going to be prohibitively expensive. And the concern there is that all of the assets get spent down caring for spouse A, and then spouse B lives another 30 years and doesn't have any money left. Are those the types of scenarios where that type of trust and that type of planning makes sense?
Yeah, I would want to sit down and talk to them because it can get a little bit complicated. The laws can change. There's also what we call a 5-year look back period where you have to create that 5 years prior to the Medicaid qualification. And so sometimes those circumstances don't always exist. But that's why I think it's really important to sit down with an attorney and the financial team to analyze the financial situation before anyone makes that type of a determination.
And maybe, Scott, a good place to kind of wrap that conversation is, because I think it's a very complex topic, and I think you're right. We probably don't have enough time to really delve too deep into it. I think the ending point is they need to sit down and talk in a consultative way about whether or not that's applicable to their situation specifically. And the reason this is so critical to talk to somebody that knows and cares, and that's an attorney, is because we see a lot of people who will promote this kind of planning somewhat, maybe a little bit too casually, where it's like, hey, everybody can benefit from this. Everybody needs to do this. And I think, Scott, I can sense, you're saying, hey, it's pretty complex. We probably ought to talk through it because there are pros and there are definitely cons to that kind of planning, and everything needs to be considered before you jump into that kind of planning. And you probably shouldn't take a very casual approach to just say one size fits all, everybody should do it. Is that a fair way to wrap that up?
Absolutely. And just briefly, the con would be you're losing control. You lose control over that asset. And just briefly also, I tried to make this as easy as possible. The number one thing that I hear from clients is I've been meaning to do that for so long, and it was a lot easier than I thought. I am so happy that I did that. I now have peace of mind. And so we try to make the process as easy as possible. Typically, I would meet with a client once to gather the information, and the next appointment would be a signing appointment. But other times I'll meet once and maybe a follow-up second meeting to discuss a few loose ends that they weren't quite sure of. But again, the benefit of having an attorney is the education. I'm going to provide education about the different options we talked about today. The client gets to decide, like in the Shivo case, Terry should have made those decisions. Yeah. She didn't. And then there was medical providers worried about their liability. And you have a fight, which I believe ultimately went to the Supreme Court. So we want to avoid that. The person who's creating their estate plan has the right to decide how they're going to distribute their assets and who's going to be involved in that.
Yeah. And
Yeah.
let's go.
Oh, I was just going to say, I like that a lot, Scott, because you're exactly right. You know, our whole lives we hear about putting your affairs in order, and that sounds like a very daunting thing. But truth be told, it's a very easy kind of consultative process. You know, the attorney does most of the heavy lifting. You know, you provide the information that's necessary, but boy, it gives you a lot of peace of mind on the back end to know that planning is in place.
And it's revocable and amendable. I meet with many clients 5 years later and we amend it based upon the circumstances as they exist at that time.
And that's probably where I actually wanted to maybe even wrap the whole conversation up, is right there. And that is, this stuff needs to be reviewed regularly. And I'm not going to define what regularly is, but it does need to be reviewed somewhat frequently. And if you haven't had your estate planning reviewed, reach out to us. We'll introduce you to Scott, and he can help you review that. And I'll just give you one quick ending as to why this matters. We were introduced recently to a family who had a lot of real estate assets, and they were scattered all over the country, different states, properties all over the place. And their planning was done many years ago for mom and dad. Mom and dad's planning was done many years ago, and there were 4 children involved. And because the planning was antiquated, there were certain elements of the planning that maybe at the time it was done had made sense. There were certain things they were trying to solve for that 20 years ago made a lot of sense. Unfortunately, those problems that they were trying to solve for 20 years ago were no longer applicable today when mom and dad died. And as a result, they had given up a tremendous benefit, the cost basis conversation that we'd had, because they had formed some LLCs, put the kids' names in the LLCs to help control things. And as a result of this, they had lost a lot of tax benefits that they should have received. And had somebody reviewed their planning in the last decade, they would have been able to catch that and said, whoa, we need to update your planning. And it would have, netted a result of the savings of, in this case, potentially hundreds of thousands of dollars. And then there was another element that they had missed where just because so much time had passed since they reviewed their planning, some of the properties hadn't made it into the planning. And as a result, they are being probated in multiple states now. And that's going to cost them a lot of money, because when you get probated in multiple states, you have to go through the legal process over and over and over again. And in some states like California, that's an extremely expensive exercise. So the takeaway for me was everyone really should periodically review their planning, because things change. Your situation changes, laws change, and you want to make sure this planning is current. Is that a fair way to end the conversation, Scott?
Absolutely. I do a lot of amendments, and just like you said, the federal estate tax threshold has gone up considerably since I started practicing in 2000. There are a lot of AB trusts out there because the federal estate tax was a lot lower, and it's just making it more difficult to administer when that's not needed anymore.
Perfect. Well, Scott, we appreciate you taking the last 30 minutes to be with us today and our clients, and answering a lot of these questions that I think are burning a hole in our pockets. People worry about this stuff, and I think having a good resource is the first step in getting solutions, and then peace of mind that follows. So thanks for joining us today. And to all of our clients who are on the call with us, once again, we love being with you, and we appreciate you taking the time to be with us. And we look forward to seeing you guys again next month at this time for another Market Minute call. Thanks, everybody.
Thanks.
Thank you.